There are things the land keeps quiet for years, decades, sometimes. A clause buried in an old lease. A signature on paper no one bothered to read twice. A royalty stream sitting dormant like water below a dry field, waiting for someone to drill deep enough to find it. My name is Vera Callahan. I farmed 90 acres in Mercer County my whole adult life, and for most of that time I kept my mouth shut and my head down and let the people who thought they knew better do the talking. My late husband, Dale, always said that was my greatest strength and my worst habit rolled into one. He was probably right. But there came a morning in October when I walked to the mailbox and pulled out a letter that changed what silence was worth to me. That morning I stopped being the woman who kept quiet. I became the woman who read every word on every page until she understood what she was holding. The letter was a foreclosure notice, and the thing that answered it had been sitting in a filing cabinet in my barn for 31 years. If you're enjoying the story so far, don't forget to hit the like button and subscribe. Drop a comment telling me where in the world you're watching from. I love hearing from you. I want to go back to the beginning, because none of what happened later makes sense unless you understand what 90 acres in Mercer County meant to us. To me and Dale, to his parents before us, to the woman who sold us the land in 1989 and pressed her hand flat against the hood of Dale's truck before he drove away, like she was blessing the vehicle that was carrying her fields off to someone else. Her name was Edna Pruitt. She was 73 years old and had farmed that ground alone for 11 years after her husband passed. She sold to us because, she said, Dale had the right hands for it. Farmer's hands, she called them. Rough and wide and patient. She said she could tell by looking at a person's hands whether they would care for land or just use it. I thought that was the most particular thing I had ever heard. Years later, I understood exactly what she meant. The 90 acres sat on the south end of Mercer County, where the ground flattened out toward Ridley Creek. Mixed soil not ideal but workable. Clay heavy in the low corners. Better up the slope where a ridge of sandier ground ran east to west across the top third of the property. We grew corn and soybeans in rotation, kept a small beef herd on the east pasture, and made our payments by staying lean and working long. Dale ran the equipment. I kept the books. We had 2 daughters, Becca and Lynn, who grew up understanding that every piece of equipment had a purpose, and that wasting anything was a form of carelessness you could not afford on a farm our size. The work was not romantic. I want to be honest about that, because stories like this one sometimes dress up farm life in a way that doesn't honor what it actually costs. There is nothing graceful about pulling on cold coveralls before dawn in February to check heifers in the dark. Nothing poetic about watching a hailstorm take a standing corn crop in 45 minutes 2 weeks before harvest. Nothing noble about sitting at a kitchen table in March trying to figure out which bill gets paid first when there is not enough money for all of them. What there was instead was steadiness, a kind of quiet endurance that Dale modeled from the first day I knew him, and that the farm itself seemed to demand and reward over time. The land had been farmed since the 1880s. It had survived drought years, floods, the farm crisis of the 1980s that had broken half the families in this county. It had survived all of that because generation after generation people had worked it carefully and held on when holding on was hard. Dale came from that tradition. His father, Wallace Callahan, had farmed in a neighboring township for 40 years and had taught Dale that a farm was not an investment vehicle. It was a responsibility. You didn't farm land to build wealth. You farmed it to keep it whole. You kept it whole, so the person who came after you started from something rather than nothing. That ethic showed in how Dale worked. He tiled the south quarter in the fall of 1996. 3 days of hard rain. Because the drainage problem had been there since we bought the property, and he had put it off long enough. He rebuilt the machine shed roof himself in the summer of 2002 after a wind event took the north end off. He spent every off-season maintaining equipment that anyone else would have traded in, because equipment you understood was worth more than equipment that was newer and unfamiliar. He had a saying about that, which was that a man who understood the machine he was on knew when it was about to fail, and a man who knew when failure was coming had time to prevent it. I kept the books the same way he kept the equipment. Every input cost logged, every bushel weighed and recorded, every loan payment tracked against a schedule. I had a filing system in the house that Dale teased me about because it was more organized than most small businesses he had ever seen. tax records going back to 1987, crop insurance claims, commodity contracts, equipment purchase agreements, land lease records of the parcels we cash rented at various points, correspondence with our lender. For 20 years, our lender was First Mercer Agricultural Bank, a locally owned institution that had served the county since 1948. Our loan officer for most of that time was Gene Haas, who had grown up on a corn and hog operation 20 miles south of us, and who understood, without being told, that a dry July was not the same as a business failure. Gene would call before a payment was due if the markets had been bad, not because the bank required it, but because he thought that was what you did when you were in a long-term relationship with someone who farmed. I paid him back by never missing a payment without calling first, and by always being honest about what our balance sheet actually looked like, even in the years it was not pretty. Gene retired in 2019. He sent a card to the farm. I still have it. Continental Midwest Lending Corporation acquired First Mercer Agricultural Bank in 2021. The acquisition was announced in the local paper and discussed at the co-op counter for weeks. The general consensus was cautious. The bank had been locally owned for 73 years, and everyone knew that when a local institution went to a larger lender, what you got in exchange for new capital and the upgraded systems was the loss of the people who knew your name and your history, and the difference between a farmer having a bad year and a farmer going under. That consensus turned out to be accurate. Our new loan officer was a man named Parker Webb. He was based in Des Moines and came to Mercer County twice a year to review accounts in person. He wore dress shoes to these visits, which I noticed and did not mention. He spoke in a vocabulary that was technically about farming, but had clearly been assembled from a manual rather than from experience. Terms like agricultural risk profile and operating leverage intensity appeared in his written correspondence. When I asked him once, directly, whether he had farmed or had family who farmed, he said he had a background in commercial lending with a specialization in AG sector accounts, which was not the answer I had asked for, but was probably the honest one. Dale died in February of 2022. A stroke, quick and without warning, on a cold morning when he had gone out to check the cattle before breakfast. I found him in the east pasture near the gate, on his back, on ground that was frozen solid and dusted with the last of January snow that hadn't fully melted. The sky was white. The cattle had gathered near the south fence and were standing quiet, the way cattle sometimes do when they sense something wrong. I stood there for a long time before I could make my hands work to call for help, long enough that later I couldn't account for exactly how much time had passed. What came after that was the ordinary machinery of grief, complicated by the fact that the farm had to run regardless. Becca moved home for the spring planting season. Lynn came when she could from Columbus. The three of us ran the 90 acres through that first year, the way you run anything after a loss. By routine, by muscle memory, by not looking too far ahead, because too far ahead was a direction that only had more loss in at first. Continental Midwest sent a condolence card. 2 weeks later, they sent a rate review notification. In August, Parker Webb came to the kitchen table with a folder of updated documentation and a revised lending agreement that increased our interest rate by 1.5 points and required quarterly financial reporting. The rate change alone added $400 a month to our payment obligation. I sat at that table and looked at the numbers and understood what they would mean over time. I signed it because I was exhausted and grieving and because I did not yet know how to fight in the language Parker Webb spoke. That was my mistake. I knew it before I put the pen down. I knew it because Dale would have called Gene Haas before he signed anything, and Gene Haas was not there anymore. The winter that followed was tight. The payment stretched past what the operation could absorb without drawing on savings Dale, and I had put aside over 15 years. I started pulling from that account in September. By October, I was behind, and Parker Webb's calls had stopped being inquiries and started being notices. Then came the letter. 30 days to cure default or face foreclosure proceedings. Full balance acceleration. Loss of the property. The language was precise and cold and left no room for the kind of conversation Gene Haas would have had with me before it ever got to a letter. Continental Midwest intended to enforce remedies secured against the property. 90 acres. The east pasture. The machine shed. The creek bottom and the slope ground. The red barn where Edna Pruitt had once dried tobacco, and where Dale had put the green filing cabinet against the far wall in 1988 and never moved it. I sat at the kitchen table a long time that night, long enough for the coffee to go cold twice. Becca sat with me, not talking, which was the right thing to do. Lynn called from Columbus and said she could be there by morning. I told her not to drive in the dark. What I did not do was panic. I had farmed this land through drought and debt and death. A letter from a man in a Des Moines office building who had never once gotten his dress shoes muddy on my behalf was not going to end something that 3 generations of work had built. I just needed to understand what I had to work with. I went to the barn. The filing cabinet was exactly where it had always been. 2-drawer, green metal, old enough that the label slots on the front were the cardboard kind with paper inserts, not the plastic kind. The top drawer handle stuck, unless you pulled it up and out at the same time. I had learned that trick from Dale and had never thought to teach it to anyone else because it seemed like the kind of thing that didn't need teaching. You just figure it out. Dale had used the cabinet for equipment manuals, warranty papers, and anything he considered too important for the house. I had my system in the house, and he had his system in the barn, and we had never fully merged the two. After he died, I had gone into the cabinet once, briefly, looking for the baler serial number, and I had not had time to go through it carefully. There had always been something more urgent. That night, I went through it the way it should have been gone through a long time before. Every folder, every envelope, every loose paper. Most of it was what I expected. Equipment warranties. Some for machines we no longer owned. Machinery purchase agreements. A hand-drawn field map Dale had made when we first tiled the south quarter, pencil on graph paper, with his handwriting noting drain tile depth in the margins. Insurance binders from 3 different carriers over the years. A small envelope labeled seed contracts with handwritten yields tracked against varieties going back to 1995. A manila folder at the very back of the bottom drawer, unlabeled, slightly damp along the bottom edge from a water leak that had happened years ago and been repaired without anyone checking what was near the floor. Inside the unlabeled folder were 4 documents. 3 were straightforward. A crop insurance policy from 2003, a drainage agreement with a neighboring parcel from 2007, a custom farming contract that had expired in 2011. The 4th stopped me. It was a mineral rights lease agreement. The date at the top was March 14, 1991. The lessor was listed as Edna Marie Pruitt. The lessee was Barlow Energy Services of Tulsa, Oklahoma. The subject property was described with full legal description. The south 90 acres of Section 14, Township 8 North, reigned for East Mercer County. The same 90 acres I had owned since 1989. The lease term was 5 years from the date of execution, with automatic renewal provisions in the event of production. The royalty rate was specified at 1/8 of gross proceeds from any oil, gas, or associated hydrocarbons produced from the property. There was a delay rental clause, a shut-in royalty provision, and a addendum clause that extended the lease as long as production continued in paying quantities. At the bottom of the last page was a clause that I read 3 times before I let myself believe what it said. In a section labeled Assignment and Successors, the rights, obligation, and royalty interest described in this agreement shall run with the land, and shall be binding upon and inure to the benefit of the parties hereto and their respective heirs, successors, and assigns. Runs with the land. I sat on the cold concrete floor of the barn office with a lease in my lap for a long time. The cattle shifted in the neighboring stall. Wind worked at the roof seam above the door. The overhead bulb cast a flat yellow light across the page. I did not know exactly what the legal implications were. What I knew was that Edna Pruitt had signed a mineral lease in 1991, 2 years after she had sold me the land, and that the lease said it ran with the land, and that I had owned the land since 1989, and that a producing well generates royalty payments, and royalty payments are money, and money is what stood between me and losing the farm. I also knew that Dale had put this paper in the cabinet. He had found it somewhere in the closing documents or in the records Edna had handed over with the property, and he had filed it, which was what he did with everything that mattered, and he had never mentioned it, which was also what he did with things he filed. He didn't announce what he preserved. He just preserved it. I went inside at 3 in the morning, made fresh coffee, and sat at the kitchen table with a legal pad. I wrote down every question I needed answered before I could understand what I was holding. By the time the sky started going gray over the creek bottoms, I had 2 pages of notes and one name I needed to find in the morning. An attorney who understood oil and gas law and who practiced in Mercer County were close enough to get there by noon. Becca came downstairs at 6 and found the lease on the table beside the foreclosure letter. She stood in the kitchen doorway in her work clothes, reading both documents without sitting down, the way Dale used to read anything that required full attention. Standing up, leaning slightly forward, reading every word once, and then going back to the parts that mattered and reading them again. When she finished, she looked at me. "Mom, where did this come from?" "Your father kept everything." She read the successor clause again, her finger moving under the line. Then she said, "We need a lawyer." I had already written that down. Russell Vane had practiced agricultural and natural resources law in Mercer County for 22 years. His office was on the 2nd floor of a building above the farm supply store on Carver Street, reached by a narrow staircase that creaked on the 3rd step regardless of how carefully you climbed it. His waiting room had agricultural extension bulletins stacked on a wooden side table and a framed aerial photograph of the county from 1978 mounted on the wall behind the reception desk. He was a compact man in his mid-50s with reading glasses on a cord around his neck and a particular quality of stillness that very good attorneys develop, the kind where you can't tell from their expression whether they're troubled by what you've told them or pleased by it or simply processing it without any emotion at all until they've thought it through. He went very still and quiet when he read the 1991 lease. He read it twice, slowly, turning each page carefully. He opened the successor clause and read it a 3rd time. Then he set the document flat on the desk and pressed his fingertips together. "Tell me exactly how you acquired this property." I told him everything. The 1989 purchase from Edna Pruitt, the warranty deed, the title examination done at closing, the fact that no one at closing had mentioned a mineral lease or any reservation of mineral rights, which meant either the title search had missed the lease entirely or the mineral rights had transferred with the surface estate as part of conveyance. Russell nodded slowly. In this state, mineral rights transfer with the surface estate unless the deed contains an express reservation or there is a prior recorded instrument severing the mineral estate from the surface. Was there any reservation language in your deed? I didn't have the deed with me. He asked me to get a certified copy from the county recorder. Becca left immediately and drove to the courthouse while Russell and I continued talking. He asked about the loan, the foreclosure timeline, every communication I had received from Continental Midwest going back 18 months. I gave him everything I had brought with me. He made notes on a yellow pad without interrupting, which I appreciated because it meant he was letting me tell it in order rather than guessing ahead of me. When Becca came back with a certified copy of the 1989 warranty deed, Russell read it in less than 2 minutes. He set it down beside the lease. No mineral reservation. The deed conveys all right, title, and interest. That means a mineral estate transferred to you and your husband at purchase. So we own the mineral rights from 1989 forward. Correct, which means when Edna Pruitt signed a mineral lease in 1991, she was either unaware that she had conveyed those rights 2 years earlier, or there was some misunderstanding at closing about what the deed included. Either way, she leased rights she may not have owned. Now, he paused. That sounds like a problem with the lease. In some circumstances it would be, but the successor clause changes the analysis. He explained it the way a good teacher explains something technical. Not condescending, not rushing, finding the plain language for each piece before moving to the next. If the lease was recorded, which we can confirm through a title search, and if it referenced the property by legal description and included a successor clause, then any production company that drilled on this land had an obligation to identify the actual mineral rights holder before paying royalties. If Barlow Energy drilled and paid Edna, they paid the wrong person. If they drilled and couldn't locate the current owner, they should have been paying to escrow. If they never drilled, the lease may have expired. We need to know which of those is true. Sandra, his paralegal, appeared in the doorway as if summoned. Russell asked her to run a search on Barlow Energy Services of Tulsa and on any recorded oil and gas activity on the subject parcel through the State Energy Commission database. She came back with preliminary results in under 2 hours. Barlow Energy Services of Tulsa had been acquired in 1998 by a company called Midland Basin Resources. Midland Basin had drilled a producing well on the subject parcel in 2003, designated MR Mercer 14-01. The well had produced intermittently since that year, with documented production reported annually to the State Energy Commission. Current status: active. There was a producing well on my 90 acres. There had been one for 21 years. Russell read the Energy Commission records without changing his expression. Then he looked at me over his glasses. And royalty payments have been going somewhere this entire time. The question is where. Sandra had also found the current well operator. Midland Basin had sold its Mercer County holdings in 2011 to a company called Rencourt Mineral Partners, which maintained a regional office in the state capital. She had a main number and a landowner relations contact. Russell made the call himself, from the speakerphone on his conference table with Becca and me sitting across from him. He identified himself, the property, and the legal context in 3 sentences. Then he asked about the royalty history on MR Mercer 14-01. The pause on the other end lasted several seconds. Then the voice, a man who gave his name as Davis and said he handled legacy account reconciliation, said, "That parcel has an open royalty account. We've had it flagged since the Midland Basin acquisition. The contact information for the original lessee went stale during transition, and we have not been able to locate the current mineral rights holder. Royalties have been accruing into a suspended escrow account since 2012. We file the balance annually with the State Unclaimed Property Division." Russell said, "Accruing since 2012 at what production rate?" "I need to pull the exact figures. Can I call you back within the hour?" He called back in 40 minutes. The suspended escrow account held $214,000. Current production was generating approximately $18,000 annually in royalty payments at the 1/8 rate. The well showed no signs of decline in the most recent assessment. Becca put both hands flat on the table. The outstanding balance on my Continental Midwest note was $162,000. I sat in that conference room and looked at Russell and thought about Dale in the east pasture on a white February morning, and the cattle gathered quiet at the south fence, and the way the sky had looked. I thought about him taking that cabinet off his parents' farm in 1988 and setting it in the barn corner, and never explaining why. Because Dale didn't explain things he considered obvious. He had put the lease in the cabinet because it was attached to the land, and you kept what was attached to the land. He had not known, probably, that Edna had signed it 2 years after the sale. He had not known there was any confusion about the mineral rights. He had just known it was a document connected to property, and therefore it stayed. 31 years in a filing cabinet, patient as groundwater, waiting for someone who needed it. If you're hooked on this story, make sure to subscribe and turn on notifications so you never miss an upload. Your support means everything and helps me bring you more emotional stories like this one. Russell spent the rest of that afternoon building the case document by document. The chain of title ran clean from Edna Pruitt's ownership to the 1989 conveyance to Dale and me, with no mineral reservation recorded at any point. The 1991 lease had been recorded in Mercer County in April of that year, which was a critical fact. Recording meant it was a public document, which meant any title examination done on behalf of Continental Midwest at the time of acquisition or at any point during a loan relationship should have found it. The successor clause was clear and legally standard language in oil and gas leases, and the Rencourt escrow account existed, was documented, and held more money than the loan balance. There was one further matter Russell addressed before he drafted his response letter. He requested from Rencourt's legal team a formal statement of the current royalty account balance, the production history from MR Mercer 14-01 going back to first production in 2003, and confirmation that the royalty interest attached to the identified parcel rather than to any individual. That last point was the one that mattered most to the bank. The royalty interest was a property right, not a personal right. It ran with the land, which meant it was part of the collateral that Continental Midwest had used to secure the loan, which meant the bank, in its own filing, had a security interest in an asset whose value exceeded the loan balance, and had never bothered to determine that the asset existed. That was the part that made Parker Webb's foreclosure notice not just wrong, but embarrassing for the institution that sent it. Russell's letter went out the following morning. He did not write it to humiliate anyone. He wrote it the way good attorneys write letters when they have the better position. Plainly, specifically, and without room for interpretation. He identified the mineral lease, established a chain of title, cited the Energy Commission records, referenced the Rencourt escrow account and its current balance, and stated clearly that my intention was to satisfy the note in full within 60 days pending resolution of the unclaimed property claim. The final paragraph was the kind that lawyers write when they want the other side to understand the full scope of what they're dealing with. Any attempt to proceed with foreclosure prior to satisfying corrected account balance and acknowledging the mineral rights interest will be documented and reserved for potential action regarding inadequate collateral due diligence. Parker Webb called the afternoon. The letter arrived at Continental Midwest Legal Department. He did not sound the way he had sounded on any previous call. The particular flatness that had characterized every conversation we had was gone, replaced by something carefully neutral that was clearly the result of someone choosing their words very deliberately. Mrs. Callahan, I've been forwarded correspondence from your attorney regarding the property. I know. We're going to need time to review the documents and consult with our title team. You have 30 days, I said, same as you gave me. He started to say something, and I told him to direct any further questions to Russell and ended the call. The unclaimed property claim took 43 days to process through the state. Russell navigated the paperwork with Sandra and with Rencourt's legal team, who were cooperative because they had been trying to close the open account for years and had a legitimate interest in getting the funds to the rightful owner. The state process required documentation establishing the chain of title from Edna Pruitt through the 1989 conveyance and forward to my current ownership. Russell assembled that package in 2 days and filed it with the state unclaimed property division on a Thursday. The state assigned a case number and a reviewer. Continental Midwest suspended foreclosure proceedings on the 6th day after Russell's letter, without announcement or phone call. Parker Webb sent an email to Russell stating that the account had been placed in administrative review pending clarification of the collateral position. Russell responded that clarification was not required on our end and that the bank should prepare its payoff documentation. 43 days after filing, the state released the funds, $214,312. Russell received the wire into his trust account and called me from his office at 4:30 on a Wednesday afternoon. The money is here, he said. Do you want to pay them today? I want to pay them today. The payoff wire went to Continental Midwest the following morning, $162,000, full balance, including accrued interest. Russell requested a release of lien, which the bank was legally obligated to provide within 30 days. He received it in 11. He filed the release at the county recorder's office himself and brought me a certified copy in person, driving out the farm on a Thursday afternoon with the document in a folder on the passenger seat of his truck. We stood at the kitchen table, and I read every line of the way I had trained myself to read every line of every document that touched this land. Lien released, balance satisfied, encumbrance removed. The 90 acres of Section 14, Township 8 North, range for East Mercer County. Mine. The remaining $52,000 from the Rencourt escrow stayed in the farm operating account at Mercer County Farm Credit, where I had already moved all our accounts. Our new lender was a woman named Joan Fleck who had grown up raising hogs south of town and who had reviewed our financial records and said, without any discussion of debt service coverage ratios, that the operation looked solid and she looked forward to a long relationship. The $52,000 was 2 full seasons of operating capital without borrowing. The first time in 3 years, I didn't check the account balance in the middle of the night because I was afraid of what I would find. Parker Webb called one final time, a week after the payoff posted. He said Continental Midwest appreciated our years of business and hoped we would consider them for future financing needs. I let him finish the sentence. Then I told him that our future financing was being handled by people who understood what they were lending against and wished him well in a tone that was technically polite and genuinely nothing else. There is a particular satisfaction in that kind of goodbye. Not cruel, not dramatic, just clear. The news traveled through the county. The way things still travel in places where people have known each other for decades, not by announcement but by accumulation. At the co-op counter, at the grain elevator, at the diner on Route 9, where the same 6 pickup trucks sat in the same 6 spots on weekday mornings. People heard different versions of the story at different times, and all the versions were slightly different in detail, but correct in essential fact. The bank had tried to foreclose on a widow's 90 acres, and a mineral lease in a filing cabinet had paid off the note. Old Carl Munson at the co-op told me he'd always said you should never throw away paper that came with the land. Carl had never said that to me in his life, but I didn't correct him. The sentiment was right even if the memory was invented. Dean Walsh from the next township overfound me at the diner 2 weeks after the payoff and sat down across from me without asking permission, which was Dean's style. He said he'd heard I'd given Continental Midwest something to think about. I said I suppose that was one way to describe it. He said that was the best thing he'd heard all year and picked up the tab for my coffee, which was the most he had spent on anything in my presence in 40 years of acquaintance. What changed more than the coffee was a conversation I started having with people I knew, not about my situation specifically, about the deeper thing underneath it, which was that paper matters. Old paper especially, documents that came with land, that were filed with deeds, that ended up in metal boxes in barn offices and kitchen file drawers and the backs of closets. Most of it doesn't matter, but the piece that does can matter completely, and you don't know which piece it is until you need it. That winter, I drove to Becca's house one Saturday afternoon and helped her go through the boxes she had brought from the farm over the years without ever looking through. She found a water rights agreement from 1962 that she hadn't known existed. She found an old drainage tile easement that clarified the boundary on the north end of property. Neither was as dramatic as a mineral lease with money behind it, but both were real and both were hers, and she had almost thrown the boxes away twice. Lynn called from Columbus when she heard about the water rights agreement. She said she was going through the boxes at her own house that weekend. I told her good. The farm continues the way farms continue. Becca is here full-time now, and the operation has settled into a rhythm that has her strengths in it rather than just Dale's. She has the same thoroughness with equipment and the same patience with cattle, and she has an aptitude for the record-keeping that I have always handled myself. I have started teaching her the system, not because I plan to stop anytime soon, but because the person who comes after you should start from something rather than nothing, which is what Wallace Callahan taught Dale, and what Dale taught our daughters without them always recognizing that's what was happening. The royalty payments from M.R. Mercer, 14-01, come quarterly now, directly to our account. Ring Court sends a production statement each quarter with the wire, and I file in my system in the house the same way I file every document connected to this land. The well is producing at roughly the same rate it has been for years. Ring Court's most recent assessment gave it another 12 to 15 years productive life at current rates, possibly longer. I don't count on estimates. I count on what arrives when it arrives, and I manage accordingly. What the well does is provide margin. A farm our size has always operated on margin or the absence of it, and the margin gap between barely solvent and comfortably viable is smaller than people outside agriculture usually understand. $18,000 a year in reliable royalty income is the difference between pulling from savings in a drought year and not having to. It's the difference between a broken pivot being an emergency and a broken pivot being a repair job that gets scheduled when it's convenient. It doesn't make the farm rich. It makes it stable in a way it hasn't been since Dale died. There's a framed document on the wall of the barn office, mounted behind glass. In a frame, Russell's paralegal Sandra found at the hardware store and assembled herself as a gift. It is a certified copy of the lien release. Below it, in the same frame, is a photocopy of the successor clause from a 1991 mineral lease. 2 documents, 12 lines of text between them. The rights, obligations, and royalty interests described in this agreement shall run with the land. They did run with the land. They ran with it through Edna Pruitt's ownership and through mine, and they waited in a filing cabinet for 31 years because Dale Callahan understood that you kept what was attached to the land even if you didn't know what it was for. That instinct, which was just a habit of a careful farmer who respected paper the way he respected ground, is what saved this farm. Not me, not the attorney. not the state unclaimed property process. Dale's habit of putting important things where they could be found. Last spring, I planted the south quarter to soybeans. They came up clean, and even all the way down to the creek, which doesn't always happen in that low ground. In June, when they were ankle high and the sky was going wide and blue past the tree line, I walked the field edge in the early morning way I have walked it every spring since 1989. The ground was soft and good and still held moisture from a May rain that had come at exactly the right time. I thought about what the land keeps quiet and what it eventually gives back. I thought about 31 years of mineral lease sitting in a green filing cabinet, patient as everything this county has ever waited for. I thought about Dale pressing that cabinet into the corner of the barn in 1988 and never explaining why, because he didn't explain things he considered obvious. And I thought about Edna Pruitt's hand on the hood of his truck and what she said about knowing a person by their hands. Dale's hands had kept the lease. His hands and his habit, and his understanding that a farm is not just what you can see on the surface of it. A farm is everything it contains. The soil chemistry and the drainage tile and the waterway and the fence lines and the cattle in the east pasture and the documents in the filing cabinet and the mineral estate 300 feet below ground. All of it, together, belonging to the person who stays and works it and holds a whole when everything else tries to pull it apart. The fields were still there. The work was still mine. And the ground, which had always known more than the people standing on it, had finally said what it needed to say. Thank you so much for watching until the end. If you loved this story, check out the other videos on your screen now. I think you'll really enjoy them. And don't forget to subscribe if you haven't already. See you in the next story. Let me tell you more about Parker Webb and the month that led to the letter, because context matters, and because I think it's important to understand how a bank takes something away from a person gradually before it takes it in one formal document. The first quarterly financial report Continental Midwest required, after the rate adjustment, was submitted in November 2022. I sent everything Russell would later describe as exactly what a lender needs to see: profit and loss, cash flow projections, a current equipment list with estimated values, the year's crop receipts from the elevator, the cattle inventory. Parker Webb reviewed it and sent back a list of follow-up questions. One of the questions was whether we had any outstanding judgments or liens. The correct answer was no, and I said so. Another asked whether we held any recorded mineral interests or leases on the property. I checked the house files and found nothing in what I kept, because what I kept was the loan documents and the operating records. The mineral lease was in Dale's barn cabinet. I answered no. That answer was not a lie. It was a result of not knowing what I didn't know. But it meant that Continental Midwest's own files now contain a written representation from me that there were no mineral interests on the property. That fact would matter later, in a way that worked against them rather than against me, because the mineral lease was a recorded document in the Mercer County recorder's office, available to any title examiner who pulled the chain of title. My not knowing about it didn't eliminate it from the record. Their not finding it, when they had access to the same record and a professional obligation to examine it, was a different kind of problem. Russell explained this to me with the particular quiet satisfaction of an attorney who has found the other side's error and is letting it land without drama. They relied on your representation instead of doing their own search. Standard practice in a full collateral review would have included a title examination. They appear to have relied on the existing policy from the prior institution and the borrower's self-certification, which means they had a security interest in a mineral royalty stream that they did not know existed, and that was worth more than the loan balance. That's not a small oversight. I asked them what it meant in practical terms. It means they were threatening to foreclose on collateral that was, if properly valued, not in default. A lender cannot accelerate and foreclose when collateral adequately secures a debt unless there's a genuine default that can't be cured. Once we establish the royalty stream's value and your intent to pay in full, their position becomes legally questionable and practically indefensible. He said it calmly, like someone describing the weather. The second thing I want to tell you about is a will reading, or rather the thing that functioned like a will reading in our situation, which was a formal letter Continental Midwest sent in late September, 37 days before the foreclosure notice, informing me that my account had been classified as a problem asset and transferred to their special assets division. That letter came with a new contact number, a new name. Not even Parker Webb, but someone else entirely. A woman named Christine Bellows, who I called once and who explained in detail, and without apology, that special asset accounts were managed differently from standard agricultural loans, and that the primary objective was resolution of the delinquency rather than relationship management. Resolution of the delinquency. I had farmed for 35 years. I had made hundreds of loan payments. I had sent financials on time and maintained the property, and kept the land productive through droughts that took lesser operations in the same county. And in Continental Midwest system, after one bad year following my husband's death, I was a problem asset being managed toward resolution. There is a particular quality of humiliation in that kind of bureaucratic reduction. It doesn't come with a witness. There is no room full of people watching. It comes in the form of a letter on corporate letterhead, using precise language that has been designed to be technically accurate, while communicating very clearly that you are no longer a person in the institution's view. You are a file. You are a number in a risk column. You are a property to be recovered. I put that letter in the same folder as the foreclosure notice, and I kept them both because I understood by then that documentation was protection and that I needed everything I had. The third thing I want to tell you about is what happened when I told Becca we might lose the farm. This was a conversation I had put off having, because putting it off was easier than watching her face when I said the words. I had told her about the rate increase and the quarterly reporting. I had not told her about special assets or about the foreclosure notice until the night I got it. Becca sat at the table and read the notice the same way she read the mineral lease, slowly and completely, going back to the lines that mattered. When she looked up, her face was very still. She said, "Did you know this was coming?" I said I had known it was possible for a few months. She was quiet for a long time. Then she said, "Why didn't you tell me?" I told her the honest reason, which was that I thought I might be able to fix it quietly before it became real, and I didn't want her to carry the worry if it turned out to be unnecessary. She said, "Mom, I came back to this farm after Dad died because it needed 2 people. I can't help you if you don't tell me what's happening." That was a conversation that opened things back up between us. I had been carrying the financial situation alone for months. The way Dale carried things he thought were his responsibility. The way I had always run the books by myself because it was my domain, and I knew the system. But our farm had never been run by one person. Dale had the equipment and the land. I had the records and the money. We had been 2 halves of the same operation for 34 years, and after he died, I had tried to be both halves, and I had done it badly, not because I wasn't capable, but because no one is capable of being 2 people. Having Becca know the full picture, sitting with both of us in a room when Russ explained what the lease might mean, watching her go still and flat-palmed on the conference table when she heard the number in the ring court escrow account, being 2 people again instead of one person trying to do everything. That was what changed the weight of those weeks. Not the money, though the money mattered enormously. The being 2 again. Lynn drove up from Columbus the weekend after the state released the funds. We sat in the kitchen, the 3 of us, with the Wren Court wire confirmation on the table and the original 1991 lease beside it and the foreclosure notice at the edge of the stack. Lynn read the succession clause 3 times in a row. Then she laughed, which surprised me, because Lynn is not usually someone who responds to relief with laughter. When I asked her what was funny, she said nothing was funny. It was just that she had been afraid every night for 6 weeks that we were going to lose the farm, and the idea that a document in a green filing cabinet was going to pay off the whole note was the most Dale Callahan thing she had ever heard in her life. She was right. It was exactly the most Dale Callahan thing that could have happened. We paid the note 3 days later. Lynn stayed for the week. We planted winter rye on the creek bottoms that Dale had always meant to get to for erosion control and had never gotten around to. It was the first field work we had done together since he died, the 3 of us, and there was something that happened standing in that bottom ground in the cold afternoon that I don't have the right words for. Something about completing what he had started. Something about the fact that the land was still ours and we were still on it and the work was still possible. Becca drove the tractor. Lynn walked the rows checking seed depth. I stood at the field edge where the slope came down to meet the bottoms and watched them work. The creek moved quiet in the trees behind me. The rye seed was going to ground. The sky was wide and gray and a long way off, and everything was still there. That is the thing about this kind of story that I want to be careful to say correctly. The money was real, and the relief was real, and being able to pay the note and keep the farm was a genuinely good outcome. But the most important thing was not the money. The most important thing was what the money represented, which was a decision Dale made in 1988 to put a filing cabinet in the barn corner and keep what belonged to the land, and the land's decision, if you want to call it that, to hold the lease patient and quiet for 31 years until someone needed it. Farms are not investments. They are not assets. They are not collateral positions or debt service ratios or problem files awaiting resolution. They are places where specific people have done specific work for a long time and left something behind for people who come after them. Sometimes in the form of good drainage and maintained equipment and clean fields, and sometimes in the form of an unlabeled manila folder at the back of the bottom drawer of a green filing cabinet that sticks unless you pull up and out at the same time. I have tried to be honest about my part in all of this. I didn't know about the lease. I didn't find it until I had no choice but to go through the cabinet carefully. I made the mistake of signing the rate adjustment without fully understanding what I was signing. I kept too much to myself for too long in the months after Dale died, which cost me time and possibly options I didn't know I was losing. But I also went to the barn when I got the letter, rather than sitting down and accepting what the letter said. I went through every file, rather than stopping when I had found enough to set aside. I called a lawyer, rather than calling the bank to beg. Those choices mattered, and Dale kept the lease. That choice mattered most of all. Russell billed me for 22 hours. I paid the invoice the same week the payoff cleared from the operating account, and I sent a note with a check that said something about gratitude, which he called me say was unnecessary but appreciated. He has a client now, Carl Munson's daughter-in-law, with a boundary dispute on the east side of her property. He asked if I would talk to her about my experience working with him. I told him I would talk to her about it, and also about the importance of going through every file cabinet her family owns. He laughed. He said that was probably the best advice either of them could give her. The well at M.R. Mercer, 14-01, continues to produce. The meadow above it looks like any other meadow in the county. A patch of mixed grasses on the north edge of the property, with a small wellhead visible from the road, if you know what you're looking for. Most people who drive past don't know what they're looking for. I didn't know what I was looking at for the first 20 years I owned the land it sits on. I know now. Every spring when the royalty statement comes, I walk out to that patch of meadow and stand above the wellhead for a few minutes, not to look at it, just to be near it, to acknowledge what the ground gave back. There are things the land keeps quiet for years, and there are things that are worth keeping quiet for exactly as long as it takes for someone to need them. I want to tell you one more thing about the county recorder's office, because it is part of this story and because it says something true about how these situations actually resolve. When Russell filed the lien release, I drove with him to the courthouse. He did not need me there. The filing was procedural, a clerk's window, a document, a stamp, a fee. But I wanted to be there because I had been in that building before under worse circumstances, and I wanted to know what it felt like to walk in with a document that said the land was mine without condition. The clerk who processed the filing was a woman I had known for years, a woman whose family had farmed north of us through the 1990s before they sold. Her name was Pat Norris, and she had been at the recorder's office for 18 years. She looked at the release of lien, and she looked at me over her counter, and she said, without making it dramatic, "Glad to see this." 2 words, no ceremony, but in a county recorder's office, among people who spend their lives processing documents that represent the passage of property between families and institutions, glad to see this is not nothing. Pat Norris had seen enough foreclosures in her years at that counter to know what the alternative looked like. She had probably filed some of them. She filed this one the same way she filed everything. Thank you so much for watching until the end. If you love this story, check out the other videos on your screen now. I think you'll really enjoy them. And don't forget to subscribe if you haven't already. See you in the next story.